Order the Special Magistrate Code Enforcement hearing for the City of St. Pete Beach for Monday, February 9th, 2026. Hello, my name is Erica Augello, and I am the appointed Special Magistrate to hear today's cases. I am a practicing attorney licensed by the Florida Bar and board certified in city, county, and local government law. I have been appointed to this position in accordance with the authority set forth in Chapter 162 Florida statutes and the City of St. Pete Beach Code of Ordinances. I am not an employee of the City of St. Pete Beach and do not represent the city here today, and I do not confer with the city's code enforcement officers outside of the hearing process about your cases. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order on which they appear on the agenda unless otherwise agreed. Every effort will be made to hear all persons having relevant evidence, arguments, or comments related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in, which I will do momentarily. All testimony given will be done so under oath. In all cases, since the city has the burden of proof, the city will present its case first, and then the respondent will be given an opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will make every effort to ensure that fundamental fairness and due process is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and all parties will be provided with a copy. So please ensure that we have your current address or email address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or other special exception of any kind. My role is solely to determine whether a city code has been violated and, under some circumstances, to provide a reasonable time to correct the violation by whatever means are available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline if one is provided. If you wish to present any evidence today, please sign in at the podium before you speak, and it will be necessary that you swear or affirm to tell the truth. Therefore, at this time, I will swear in any witnesses. So anyone wishing to speak today, if you could please stand up and raise your right hand to be sworn in. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
So sworn. Great. Are there any changes to the agenda today?
Good morning, Madam Special Magistrate. Yes, there is a change. Pete Doer on behalf of the City of St. Pete Beach Code Enforcement. Case number 2025-0100, which is case 5A. We'd like an order to continue the case to March 9th.
Okay, and is there any objection from the property owner on this one? Do you know Mr. Dewar?
Stephen.
I spoke to the property owner. I did inform him on Thursday that we were continuing to March 9th.
Okay. All right, perfect. Just in case, anyone here on behalf of Mr. Quintero? Okay. All right, that will be continued to March 9th at 10 a.m. And I will get an order out to that effect. Any other changes to the agenda today?
No, ma'am. Thank you.
Okay. Then moving on to agenda item 3A, case number 2025-0507, City of St. Pete Beach versus Karush Bakatanarian.
Good morning, Madam Magistrate. Steve Rivera, City of St. Pete Beach Code Enforcement. This is a status hearing for the short-term rental. We were able to get his paperwork processed, reviewed. He was eligible for grandfathering, so the city's requesting that we just get an order of dismissal.
Okay. I will go ahead and get the order of dismissal to you. And then moving on to item 3B, case number 2025-0220, City of St. Pete Beach versus Mr. Starkis.
Good morning again, Steve Rivera, City of St. Pete Beach Code Enforcement. This was a status hearing for the compliance for repairs to the property. Mr. Sarkis stated that he was splitting the lots and was going to demo. The demo permit's still on hold. It looks like the other lot was sold. There's no changes with the property. At this point, the city's requesting that, as of today, we start the $250 a day fines until compliant.
Okay, has the demo permit been applied for?
It was applied for, and then it was requested to be put on hold based on the sale of, the splitting of the property and sale. The rear lot in property appraiser is showing that the property is sold. The front lot he still owns, and there's been no changes since then.
Okay. All right, Mr. Starkis? Why don't you come up and tell me what's going on with the property?
The situation is that I own two properties over there, and because this one I got you know, a lot of damages, and I applied for permit, but situation is that few weeks ago another property people they bought already, and we signed a contract on this one too, because
On
they
this
want
one.
to split those, and they've been here like few times already, and zoning probably department, they approved already that they can split the way those lots, and I have signed contract already. Only closing is gonna be, I'm expecting in the March. Last time I talked with them, and they already did a lot like they did soil test, pay deposit, they did survey, and I've been here. I came, explained that I have that situation. Maybe we can put on the hold that permit, and when we will have closing, maybe we can transfer, or they're gonna take their own permit, and so
Okay.
it's the easiest way to resolve that.
So at this point, you are working towards, there's a contract for sale. You anticipate the closing on this property, this lot will be sold in March. Do you have a,
I have contract that actually it is for longer time.
okay,
Because they collecting finances for the second property.
The second one, okay.
This issue, but when I talked last time with them, they said probably they're gonna be ready in the March.
in March?
In March, yes. So
Okay, so you are working towards selling this property, the demolition permit's on hold because you're hoping that they will purchase it and then they will take over the demo
Yes.
permit from you?
yes.
Okay, okay. Thank you very much, I appreciate that. Anything else from the city?
No, ma'am, I haven't heard from him. The last conversation I remember having was that he was splitting the lots. And at this point, I'm not sure which direction we're going with it, so that's why we're putting in a request.
Okay, all right, because Mr. Sarkis, I mean, we've been going through this for a while, it was trying to be insurance and then whatnot. He is making a good faith effort to get the property sold, to have it demolished, whatever the new owners are gonna do with it. So since we have an anticipated closing date in March, I will sit this again for a status conference on April 13th. Obviously, we can look then to see if the property is going to be sold or if there's any delays in that. I don't want to issue any orders putting daily running fines on a property that might actually hold Mr. Starkus up from getting it sold and then the city being able to garner compliance because it will be demoed. So
Can we request that he send us a status email at least, so that this way we can update our notes to know what's going on with the property?
yeah, I'll go ahead and include that in my order. Are you okay with that, Mr. Sarkis? That as soon as you know, like every 2 weeks or so, you can send an email over to Mr. Rivera and just let him know what's going on? Okay, thank you.
Madam Special Magistrate,
Yes.
Pete Dewar, can we, instead of April, ask you to do March, since he would not, if this
Well, I
transaction...
believe the information was at the end of March they would be closing. Is that correct, Mr. Sarkis?
Yes, that's what I heard from those buyers.
From the buyers.
Planning for March to have closing.
Right, so I don't want to set it for the beginning of March if closing is set for mid or the end of March.
There's nothing to compel him to come back if it's sold.
But that's correct, but also underneath Chapter 162, if there's a transfer of ownership, then he notifies you anyways. And again, we are working towards compliance. That's, my goal here is to make sure it's fair and equitable. I think putting a daily running fine on this property when he is attempting and under contract to sell it actually puts him in a worse position and puts the city in a worse position for compliance, because now you have an obstacle that needs to be overcome. I mean, keep in mind, what's going on this property was subjected to the 2024 hurricane. So, you know, and so far, Mr. Sarkis has done everything that's been asked of him, and he's been trying to go through. So I find the testimony credible, and I'm going to set it for the April 13th because I think if it's at the end of March, then we just come back here for no reason.
Thank you.
And then again, in my order, Mr. Sarkis, it will say just to email Mr. Rivera so that he can keep tabs on what's going on.
I'm not sure we have your business card. I think I
Okay, and moving on to item 3C, case number 20230606, City of St. Pete Beach versus Mark B. Broderick and Lynn M. Broderick.
Thank you, Madam Magistrate. This was a status hearing. They were supposed to go to the Board of Adjustments. The attorney for the case had emailed us. They're still submitting paperwork. I believe the hearing, they're supposed to have their paperwork in by Friday. They're requesting that this be continued till March.
Okay, and does the city object to that?
No, ma'am.
No.
No? Okay. Is there anyone here on behalf of Mr. or Mrs. Broderick? Okay, I will go ahead and get an order out that this is continued until the March 9th hearing at 10 a.m. All right, and moving on to item 3D, case number 2025-0061, City of St. Pete Beach versus Christopher Paget.
Good morning, Special Magistrate Ayaka Ruckshell, City of St. Pete Beach. This is a status hearing for the property at 544 72nd. They had to obtain a fence permit that was secured on January 16th, so the property is now compliant.
Okay, and is the city just asking for administrative costs on this one? Okay. I don't see Mr. Paget here. Is Mr. Paget here?
I don't think he was.
Okay. All right, then I will find that as of January 16th, 2026, the property came into compliance, and I'm not going to issue any fines, but I will assess was it $330?
130, yes.
$330 in the reasonable administrative costs of the city.
Thank you.
All right, moving on, there are no repeat violations, so agenda item 5B, which is case number 2023-0682, City of St. Pete Beach versus,
Stays on.
thank you, Saison Ventures LLC.
Thank you, Madam Magistrate. Stephen Rivera again, City of St. Pete Beach Code Enforcement. Case number 2023-0682. Respondent is Saison Ventures LLC. Violation address is 4105 Gulf Boulevard. Violation description: the property is in violation of Section 123.1, permits required, 98-3B, mailboxes, address signs, 9864A, general conditions, 9865-1B, 3 and 4, unsightly conditions, 9866A, B, 2, A, B, and 7, residential and commercial property maintenance, 4633-2 and 3, enumeration of the Code of Ordinance of the City of St. Pete Beach. Case summary: initial inspection was 12/6/2023. Amended notice of violation dated and mailed certified was 12/2/2025. Amended notice of violation compliance date was 12/29/2025. Notice of hearing dated and posted to the property 1/21/2026. Following is a true and accurate representation of what I witnessed. This is the affidavit of posting at 4105 Gulf Boulevard. This is a picture of the property. It was a previous commercial structure. It's a picture of where the sewer line, the cleanout is. That was installed without a permit. If you see here where the red arrows are, you can see where it goes all the way out to, looks like going toward the street. This is where the second cleanout is, up by the street. The sinkhole that's on the property, this is toward the rear of the property near the seawall. This picture here shows it looks like it was filled in, but it's starting to sink again, so it doesn't look like it was properly repaired. Another picture, you can see where the dirt's discolored there. A picture of the brush pile that's in the rear parking lot of the business. And you see here there's gutter and soffits that are damaged. More damaged soffits and trim. And gutter here from the buildings just laying on the ground there. And you got the siding here that's missing. Now, this is an email. I was speaking with Mr. Cezanne. There was communication. We did an inspection back in '23, and this is part of the reason why the case is as old as it is. He was working toward compliance. We did have an open line of communication. If you read in the email, at one point, he did have a plumber that did try to come in to get a permit. It was during the height of our permitting issues. I won't say issues, I should say delays because of the storm. I did express to him, in the next slide, you'll see there was another email. I wish he'd have came and spoken to me prior to that. He did tell me that he was looking to demo the building. If you see number 4, this is the building will be demolished before 12/31/2024. And let me know.
I was going to say, well, this is August 23rd, 2024, so this was right before the 2 storms hit back to back. Okay.
And there's another email here, him saying that the goal was to have it submitted by September. He's looking at demo companies, and it was going to benefit him to demo the property before the year was out. And my response was down there at the bottom with the communication. You know, I just wish he was communicating this with me prior to getting to that point. I did send another email here. If you look, it says January 7th, asking for an update, and I did not hear back from Mr. Cezanne.
Okay.
Corrective action. Property must obtain an after-the-fact permit for the sewer line that was replaced. Property must repair the sinkhole, properly repair the sinkhole, fix the damaged soffits, remove the brush pile in the rear parking lot, and repair the siding and flaking paint. Property is not compliant. The recommended fine is $250 a day from the date of your order, plus a $330 administrative costs and any recording fees that may be associated with this case. And that concludes my presentation.
Okay, and that last email that you had to Mr. Cezanne in January of this year, that was, or last year, that was the last communication you've had with him at
Was
all?
looking for an update. Was kind of hoping that maybe he'd reach out. Ended up having to send an amended notice of violation. Was hoping that at that point
That would
we would
trigger?
get right. And I haven't heard anything from him since our previous conversation when he spoke about demoing the building.
Okay, thank you, Mr. Rivera.
Thank you.
Is anyone here on behalf of Cezanne Ventures LLC? Okay, if you could please state your name and affiliation for the record.
Good morning, Madam Magistrate. Matthew Baylor on behalf of Cezanne Ventures. With me is Robert Cezanne.
Are you counsel, Mr. Baylor?
Yes.
Okay, go ahead.
I believe most of these issues have been addressed, and Mr. Cezanne will do a little presentation on that
Absolutely.
with the exception of the sewer, which I'll address.
Okay, and Mr. Cezanne, you've been sworn in?
I have not, no.
Okay, if you could raise your right hand briefly. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much.
Fantastic. All right, so the pictures that were showed up there are true and actual. As of 2 weeks ago or last week, the property has been brought into compliance with everything. We work with the city all the time. Stephen is right, we were going to demo the building, and that was the plan. We bought the building 3 years ago and have done nothing with the building. So we had some issues when I first bought the building. We complied with all those issues. As he mentioned, I have a copy of that same email he showed you, and we were going to demo the building. Actually, about 3 weeks ago, we just signed a lease for someone that wants to actually open the building. So we are going to be fixing the building up to even a better compliance. But to show, we can bring it up on the screen here. We filled in the hole that was there for the sewer that I have no idea about. My attorney will address the sewer issue, but that has been filled in. There's another picture of it. The front of the building is all cleaned up as well. There's no weeds or anything. The back of the building, all cleaned up. Another image here. Another image there. Trash, we removed the sides of the trash. What we had an issue 3 years ago is with bums living in there and people dumping their trash. The only way to confront that was to remove the sides so that nobody can put anything in there. Once we redo open establishment, we will properly fence it and close it again. But this is the only way to keep people from dumping trash on a property that they shouldn't be dumping, so it's see-through. And since we've done that, we've had no issue with people leaving trash. And then that's the painted front ATM where the ATM used to be. So I just saw the soffit pictures, so we will be taking care of the soffit. That's no issue whatsoever. As I mentioned, now that we have a lease on the property, we will bring it to a better standard altogether. Our plan was to demolish it, so we will be putting an address on there. We will be putting a sign out there. We will make it a proper property that the city will be proud of. I did not know about that little sinkhole area in the back. We'll address that as well. I just saw that for the first time today. So no, we want to be compliant with the city and make everything obviously.
Okay, so the gutters are up, but the soffits and the fascia
The
board,
gutters are not up yet.
the
either.
gutters are not up, okay.
Gutters and soffit are not up, no.
Okay,
No, we
so
just
the
kinda- we
debris
just
been
basically did
cleared?
Yeah, we just did a maintenance cleanup of the property, so
Okay.
it looks a lot better, but we'll get we'll get the gutter and soffit up because obviously we need that for our tenant as well.
So then let me ask you a question. I know you said your attorney will be addressing the sewer line issues, but for the remainder, how long do you think it would take for you to remedy those issues?
30 days, I mean.
30
that's all
days?
we need, yeah.
Okay. Okay, anything else you'd like me to know, Mr. Cezanne?
Nope, I'll let my attorney address the,
Thank you very much, sir.
thank you.
Mr. Baylor?
Thank you. Matthew Baylor for Cezanne Ventures. When my client purchased this property, the sewer was not something that was known to be a problem. I believe there was some type of other ADA permit that was open on the property at that time that the city notified us of, and that was closed out. Whoever had done this sewer work was not Cezanne Ventures, so we don't really know anything about it. If the city requires some type of compliance, that can be done, but we believe that whoever previously owned this property is ultimately the party that was responsible, and it should have been addressed whenever this work was done.
Okay, and you're saying there was an open permit, to your knowledge, that for the previous owner?
Yes, for a ADA compliance or something to that effect.
Yeah, it was an ADA permit that was open and closed.
Okay.
We have no record of anything on this property. When I bought the property, that's how I bought the property. So when my plumber went through the records trying to find a open permit, there was no open permit, there's nothing. So there's nothing to close because nothing was ever open. Even when we ran a title search and everything, when I bought the property, everything showed closed. So I bought the property exactly how it is. I know nothing about the property.
With the
Everything.
asphalt in the same manner that it is?
3.5 years ago, I've done nothing to the property with the sewer.
Okay.
That was how I bought the property. And per that email that I shared, I did try to bring a plumber out there to get an after-the-fact permit per the email, so I did it. He went out there, he's like, Rob, this is not my problem, it's not my job. He's like, they want me to run sewers, they want me to run cameras. He's like, he worked with the city, I think he just gave up. He said it was just so much red tape working with the city that he gave up. So I'm like, all right, it's not my problem either. I mean, it's nothing, I bought it like that, so I know nothing about it.
Okay. And so I guess the information is you bought it like that, you tried to comply, so you had a plumber who went to the city and tried to pull an after-the-fact permit for that work.
Messages on my phone that says that the city are idiots, basically, like I'm not working with them. So he
Okay.
gave up.
Okay. Okay, thank you very much. I appreciate the information. Anything else from the city?
No, ma'am. Like I stated, about the property being in disrepair, and that's what I stated. Mr. Cezanne did meet me out there. We did a full property inspection. The ball was rolling forward, and that's when we discussed the sewer line. We're not stating that he did it, but we said it had to be addressed, and that was what was laid out in the email to get an after-the-fact permit for the sewer line that was replaced.
Well, and does the city actually have proof that it was replaced? I know I can see the new PVC pipe and I can see the asphalt.
Yeah, and I have the
That
building
would
official here that can probably better answer that question looking at those photos. If
Okay.
you'd like to-
I would think too, if someone was doing work like that, they'd have to dig up the asphalt. There would probably be a couple-day project and nobody noticed that.
And I can't speak for
I know.
that. That was right around the time that I started. It was just something that I noticed during my inspection, that the PVC pipe in '23 looked new. The pictures that I have today compared to '23, the asphalt looked fresh, like it was cold patch that somebody put down recently. It was, and I agree, prior to him purchasing the property, but there was never a permit for it.
There's no record that the city has
Yes,
for a
ma'am.
permit on that. Okay. All right, yeah, if you could get the building official. Sorry, Mr. Curtis.
Good morning,
Go
Luke
ahead.
Curtis, building official. So a permit to replace that section of sanitary line is pretty straightforward and easy. There is no record in our system for the permit. Just looking at it, you can tell that it was recent, and I use that term broadly. It clearly wasn't the original, so sometime in the recent past, it was replaced. If part of that pipe is uncovered, all pipe manufactured has a date on it, so that could narrow it down as far as when that was done. But without seeing specifics or looking at a historical pictures over time, there's no way of telling exactly when it was done. but it is work that would be recovered. The permit itself is fairly easy. No review would even be required. If somebody came in applying for a permit to replace a section of sewer line, they're saying going from the building to the city tap, it wouldn't even require review. We could issue it over the counter, potentially, if they were here. There are elements to that that require inspections. So we would need to make sure that it's, the minimum set of construction standards that are set forth in the building code. And that's to protect property owners, that whoever's doing the work, and we don't know who did it. Was it a licensed plumber, or was it a handyman, or the property owner themselves at the time? And just to reinforce what Stephen was saying is, we don't, whether it was done by this property owner or the previous property owner or the property owner before that, we don't know who did it. We just know that no permit was ever pulled for it. So we just want to make sure that that work meets a minimum set of standards, which is the Florida Building Code.
Okay. And it would be a city permit. It's not a county, doesn't tie into county lines or anything of that.
City
Okay.
permit.
And so an after the fact permit, when you're talking about inspections, are you talking about that they're going to have to dig up asphalt to show anything? What kind of inspection are you talking about?
So, and I try not to beat people up too much about in a scenario like this. So, for example, if a portion by the building can be dug up so that we can see the depth of the pipe, and another portion closer towards the road, because I think there's, I don't think it's paved out there, we might be able to see enough to be able to pass an inspection. Part of it would be plugging it, make sure it's holding water. There's a series of things that we can do without necessarily having to dig up the whole section of pipe. Ultimately, when we do these inspections, that is what we're doing, is they excavate, they lay the pipe, we come do an inspection to make sure everything is tight, and then they backfill it. But at this point, we can work with an applicant.
Can that be done based on an affidavit of an engineer of any kind, anything like that?
So that comes up periodically. Well, if I provide you a signed seal affidavit from an engineer, my concern there is they can't see through the ground to see exactly the
Right.
depth and the pitch of that pipe. So it's just basically somebody being paid to say it's okay. So
Yeah, and
technically-
from my perspective, you're saying, I'm trying to balance. We've got testimony that says this is not the property owner, and I'm also with the buyer beware. You take the property subject to what was ever done. It was permitted, unpermitted. I also understand protecting the property owner and following the building code. Is there a legally cognized, I'm trying to find the path of least resistance. So if there is a way to do it by affidavit, you're saying that's not, for this particular scenario, that's not a legally cognizable way to do this.
I don't typically accept an affidavit from an engineer unless they have actually done an inspection on it. Seen it when it was. So part of the building code says that all work shall remain accessible for the inspection. So it's not accessible. So in order to make it accessible, I'm willing to work with people to clean messes up like this. And there is the potential where it could be uncovered to a certain point. Make sure it has that minimum depth at the one end, and make sure that it has, at least from appearances, enough fall so that it's going to drain properly.
Okay.
But
Okay.
it would have to be, we would document it just to say, the whole length of the pipe hasn't been seen, but if there's enough to hang our hat on to say, it's
Meets the minimum
it
standards.
appears to meet the minimum
Okay.
standards.
And if that were to be done, how long do you think it would take to secure an after-the-fact permit in that type of situation?
Honestly,
I know I'm asking you to.
No, so like I said, with a scenario like that, that type of permit, there isn't a review that's required. No other departments would have to sign off on it. So technically, if I had somebody at the counter, it could be released right then.
Okay. Okay. Thank you, Mr. Curtis. I appreciate your time. Anything else from the property owner?
Thank you. Mr. Chazon, if he has to open and close close out a permit, that's fine. The challenge here, I think, would be finding a licensed individual to come out and sign off on this work after the fact when nobody knows when it was done or what was actually done. All that's been presented is there's a pipe that looks new, but nobody can tell us when that happened, and or my client says he didn't do it, so we just don't know and think it's going to be an issue having somebody sign off on it.
Okay, and I can understand that. I will say that, you know, it appears your client is a sophisticated property owner. When you purchase a property, you do so subject to whatever the previous owner did on it. And I understand that you guys did title reports and due diligence and whatnot, but if there was no permit pulled for it, that's something that I would suggest that might be between your client and the previous property owner. Hopefully this can be resolved by an over-the-counter after-the-fact permit. Based on the testimony here today, is there anything else from the city? Sorry, before I...
No, ma'am, not at this time.
Okay. Based on the testimony here today, I do appreciate that Mr. Cezanne has made efforts to clean up the property, understanding that the property has gone through a couple different iterations as far as what was going to be done on the property over the years. So I am going to find that the property, I guess I have a question. Mr. Rivera, you cited underneath 98-3 for mailboxes, address signs. I didn't see any.
3B, it should be 3B for numbers.
That there's no numbers on the property?
There's no numbers, no, and in the first picture that was kind of just a shot of the property, you can also see that there was no numbers on the property, is why I can bring the slide back up.
No, that's not necessary. Okay. Okay, then I am going to find that the property owner is in violation of the stated code sections. I do understand that there were efforts to bring it into compliance, but there are still some outstanding things. One of those is the sinkhole. Mr. Rivera, how is that supposed to be remedied?
And again, I'm not even sure how that would be fixed, that the property owner, it keeps opening. It's not the first, that was the initial inspection. There was an inspection on the property that December was for a call about a sinkhole. And I did a full inspection of the property. Like I said, Mr. Cezanne had addressed the other issues that were in the original notice of violation. There was an issue, I think, with the fence, the dumpster enclosure. He did rectify all those issues, started working toward compliance. But this hole seems to keep coming back.
So I do have an issue with that. If the city can't articulate what compliance means, I can't necessarily force the property owner to comply when there's no standards with which the property owner is supposed to meet. So that's why I'm asking.
As far as the hole, you mean?
As far as the sinkhole, right. If the city cannot articulate this is what compliance means, then I can't say you're in violation of a code section because there's no way that you can comply.
I understand, yeah, and the concern that we have
arbitrary
is so close to
enforcement.
the property line and the seawall, I don't know if there's an issue. I know there was a permit pulled for the neighboring property. They did have a fresh seawall installed. This property has the original seawall that was there when I did the inspection. So I don't know if it's seawall related. It just seems it's safety issue is what I'm concerned about. And then it being so close to the property line.
And again, that all might be true, but if there's no way to articulate what the property owner has to do to comply, then you can't arbitrarily enforce that against them. So,
Your Honor, if I may,
Yes.
speaking with Pete, perhaps one, if it's agreeable to our officer, to require a sinkhole expert to go out and assess the situation and come up with a possible repair with an affidavit saying that it has been repaired. If there is damage to the seawall, which is I think what the city's concern is, we could address that subsequent to a licensed professional on sinkholes telling us how to repair it.
where, and I guess my question is, so you're asking the property owner to expend money to find a sinkhole expert to determine how it's going to be repaired, or the city would send out a sinkhole expert with the consent of the property owner?
I believe that it's really the property owner's responsibility to have it repaired. I don't think that the city has the expertise regarding the preparation of how to repair a sinkhole.
Right, and then we go back to my first initial concern is that if you can't articulate what repairing the sinkhole entails and the standards by which it needs to be done, that's arbitrary enforcement. So now we're putting the onus on the property owner to come up with what compliance means. And I am a little concerned with that. Mr. Cezanne, did you have something that you wanted to?
If you would, like I said, this is the first time I'm seeing that
Okay.
over there. Allow me to put some eyes on it and
Okay.
see exactly what it is. Let me dig the rocks up, see what it is. It could just be erosion that's happening somewhere. So I don't know what it is, but
Okay.
I want to make it right. So
Is
at the
that
end of the day, I
acceptable
want
to
to
the
make it right.
Is
So
that acceptable to
give
the
me-
city that he
Give me
can
the
take a look
opportunity
at
to take
it?
a look at it, and whatever it is, we are going to make it right. There's no question about it. I mean, it's my property. I want to make it right. So I got no issue with that whatsoever. So
So,
give me an
Your
opportunity.
Honor, possibly go ahead and perhaps the city would continue to request that a violation be found, and then within that 30-day period, if there is compliance, then you'll have the information at that point.
Within 30 days, I'll have the gutters up, the soffit up. I'll have my eyes on that and fix that, whatever it is. So I have no issue with that. Like I said, I want to be compliant. I don't want to have to be coming here.
Okay.
for this.
Well, let me do this.
What about the plumbing? So that's my.
So that's my next thing that I wanted to address. I am going to find that the property is in violation of the stated code sections, and I understand that that wasn't your work that was done, and I do understand the concerns that Mr. Baylor has with trying to find a licensed professional that's willing to put their mark on something that they didn't do. I think we all have those concerns. I am going to I'm going to find that that is a violation. However, I'm going to allow for 30 days for the property to come into compliance, but then I'm going to say, let's come back at the next code hearing and address if you could find something, what the issues are, and that way, because it sounds to me like it can be an over-the-counter permit if it's acceptable. If you can find somebody that's willing to just say, okay, it just needs to be an inspection. I understand the concerns on both ends. Unfortunately, I only have so much authorization in my position, and I have to base it off of the evidence that's presented here today. So
This is just a paperwork procedure. I have no problem getting a licensed plumber in here. He'll put his name on it, he'll sign it, and then as long as they close it out, he's fine with it. But like I said, I don't want to have him go through the scrutiny of being scrutinized for something he didn't do.
That
But
he
if they-
didn't
If this
do.
is just a paperwork procedure, if they just want paperwork like government always does, no problem. We'll get a stamp on it, open, close, within 5 minutes. He'll walk in.
yeah, and I think that there was an inspection process that needed to be done too. So I'm going to suggest that you guys get with the building department in the interim to find out exactly what needs to be done, and hopefully it is that easy. If it isn't, then we'll meet back here at the next code hearing, which will be on March 9th. Oh, I did say 30 days.
7 days, right?
Yeah.
I'm
Man.
going to be out of town March 9th as well.
Okay,
if we can
so
actually-
then April 13th, we'll come back here. I am still going to put my order for the 30-day deadline, but we will come back on April 13th for a status hearing. And that way we can figure out where you are, if that's all been remedied. If it's all been remedied, I won't see you here. But if it's still outstanding, then you can come back and tell me where we are in the process. Okay, and I will get you an order, just make sure, Mr. Baylor, I have your email, or Mr. Cezanne yours, then I can send you a copy of the order with the information in it. Okay. All right, thank you very much. And then moving on to the next code case. Case number 2025-0746, City of St. Pete Beach versus Michael Martin.
Thank you, Madam Magistrate. Steve Rivera, on behalf of the City of St. Pete Beach Code Enforcement. Case number 2025-0746, the respondent is Michael Martin. Violation address is 2 Alhambra Street. Violation description, the property is in violation of Section 9.2A, permitted principal uses and structures of the Land Development Code of the City of St. Pete Beach. Case summary, the initial inspection was 12/19/2025. Irreparable and irreversible notice of violation dated and mailed certified on 1/21/2026. Notice of hearing dated and posted to the property 1/21/2026. The following is a true and accurate representation of what I witnessed. This is the affidavit of posting at 2 Alhambra Street. This is the Airbnb advertisement. This is the one review that states that it was a weekend stay. Corrective action. The property can only be rented monthly. The property is compliant. Recommended fine is $1,000 per violation, one review, totaling $1,000 plus the $330 administrative costs and any recording fees that may be associated with this case. And that concludes my presentation.
Okay, did you want to put in the review policies for?
I do,
Okay.
actually.
I'll tell you what, I will take notice of the review policies.
And I am going to take full responsibility for it because I grabbed it and did not bring it with me.
That's okay. I will
Give me a second, though. We can-
accept the Airbnb policies as the review policies into evidence, and we will put those in
the-
the printout.
on my desk.
Okay. I will accept those into evidence. Is there anyone here on behalf of Mr. Martin, or is Mr. Martin here? Mr. Martin, if you could please come up and plead your case.
I was approached by a management company over the course of some time, and then agreed to do business with them, and I asked if I'd be compliant. And so, I mean, ultimately, I know it's my responsibility, but they told me I would be. So based on that, I let them run the show. So
Okay. Can I ask, the city's asking for $1,000 for the violation. It was for a girls' weekend. What's the average price per night that you rented it for? Or if you can recall what you got for that?
like $400 or $500.
For the whole weekend for them? Okay. All right. Thank you very much. Anything else from the city? The Airbnb review policy?
That was your opportunity.
He said he'd like to mention that I've never had any other violations.
Okay. Thank you very much, Mr. Rivera. Okay, I am going to find that the property was in violation of the stated code section. I am going to find that the property the nature of the violation is irreparable and irreversible. I am going to assess a $500 violation or fine for the violation, plus the $330 in reasonable administrative costs of the city, and any recording fees that might be associated with effectuating a lien in this case.
Thank you, ma'am.
Thank you. And Mr. Martin, make sure I have your email. I'll send you a copy of that order. All right, moving on to the last case of the day, case number 2026-0019, City of St. Pete Beach versus JSC Group LLC.
Okay. Good morning, Special Magistrate. Ayaka Rochelle, representing the City of St. Pete Beach. This is case number 2026-0019. The respondent is JSC Group LLC. The violation address is 510 79th Avenue. Violation description: the property is in violations of Section 9.2A, permitted principal uses and structures, and 9.5, prohibited uses and structures of the Land Development Code of the City of St. Pete Beach. Case summary: the initial inspection was on January 15th, 26. An irreparable and irreversible notice of violation dated and mailed certified on the same day, January 15th, 26. Notices of hearing dated and posted on the property, January 15th, 26. This is a true and accurate representation of what I witnessed. This is the affidavit of posting on the property on January 15th. This is the Airbnb advertisement for the property. This screenshot here shows the ability to do a 6-night rental. This is the mapped location for the property. The aerial view. And these are the 3 reviews that were found for November, December of 2025, and January of 26, which is 3 weeks ago from the date at the lower right-hand corner there, which is January 29th of 26.
Okay, so you're saying the December review,
Sorry.
that's
Go
okay.
back.
Because it looks to me like each one was posted in November, stayed for a few nights, I see that. The stayed with the pet, you're saying in the stayed with kids are within 3 weeks of each other.
Well, the one that's 3 weeks ago is 3 weeks as of the end of January. So that would have been in the beginning of January.
Okay, and then the December one,
Stayed with the pet there.
okay. And how are we sure that the stayed with the pet is a short-term rental?
Well, November would have been a few nights.
And if they stayed on November 1st?
So a few nights there in December.
Is there anything else in the review
No,
that
there
would
was no more.
Okay.
Just the location was great.
And then the one 3 weeks ago, you're saying is 3 weeks ago from January 29th,
Correct. So that's the beginning of
which would have
January.
been beginning of January.
Correct.
So it is, that would put 2 in December, is what you're saying?
No. The one in November, one in December, and then the one in the beginning of January.
Okay. Thank you.
Picture of the backyard. So the corrective action would be the property can only be rented for a minimum of 30 days. The property is not compliant. The recommended fine is $1,000 per violation. There's 3 reviews, totaling $3,000, plus $330 in administrative costs and any recording fees that may be associated with this case. And if you'd like to see the Airbnb policy,
Actually, yes, please. I think it's 14 days after checkout.
You're doing the math?
Yeah, I'm doing the math. Okay, thank you. Albeit I'm not great at math, but I am doing the math. Okay, is there anything else from the city?
nothing from the city, ma'am, but I do believe there is someone here from the JSC group.
Anyone here from JSC Group LLC? If you could please come up and state your affiliation with the corporation for the record.
My name is Sarab Arora, and I am the manager for JSC Group and owner.
Okay, can you tell me, are those 3 short-term rentals?
Yes, I believe they are short-term rentals. Today we would like to plead for compliance. And we want to notify this is our first awareness of this. This is our first warning, first notification of any type. As you can see from the date, the property was launched for any rental business in November. We have, been informed by businesses here in St. Pete and also phone numbers we try to call through the city that there are certain areas in Pinellas that are permitted to have short-term rentals, and that is why we pursued this license. I can show it to you here.
Mm-hmm. Sure.
Oh, sorry. And so I'm showing you this just to emphasize our intent was to comply. We thought we were doing the right thing. Now that the city has informed us that I called the magistrate number, so it was nice to have a contact number who could actually explain the situation. After I spoke with them, they explained that the particular address is not permitted because it's not Pinellas unincorporated. So this was all new information. If you look here, there are 2 companies who are property management companies working here in St. Pete Beach, and they both initially recommended that we could proceed. So again, we were ill-informed by the people who were supposed to be experts in this space. So again, I want to emphasize our goal has always been compliance. We invested into this property with the hope that we were following all the rules, and that we would bring value to the city of St. Pete, but if we cannot do it, we will stop. And so our goal today is to present to you a plea for compliance, a plea for relief of all the fees due to our intention, due to our attempts to be fair and compliant. And if you would be so kind, we would like to consider if it's possible to request a temporary reasonable wind down period so we can shut down this business. We come we hope for good faith reliance. We emphasize that there's a lack of harm and that the bookings that were made will cause some disproportionate hardship. If it was possible to have a few months to transition and close this down, we'd really appreciate that.
Okay. Thank you very much. I appreciate your time today. Anything else from the city?
No, ma'am.
Okay, I did have one question. What's the average nightly rental there? Or how much can you tell me that you made off of each of those rentals?
So far, there's no net profit with operating costs, but the typical charge rate per night is $200 per night.
$200 per night? Okay. And on those, what was the average night stay? I know it said a couple of days on one of them, but
I think probably like 3 nights.
3 nights? Okay. Okay. Anything else from the city?
No, ma'am.
Okay, I am going to find that the property owner is in violation of the stated code section. I am going to find that for all 3 of the reviews that were there. I am going to assess a fine of $500 per rental for a maximum of, for the $1,500, plus the $330 in administrative costs of the city, and any recording fees that are associated with the recording of a lien on that. I will say, I cannot offer you a wind down period. That would be putting me to allow you to violate the law for a specific period of time until such time as you choose not to violate the law. What will go into my order, which I will get you a copy of, it will be that within 10 business days, you will have to provide to the code enforcement department that you don't have any short-term rentals booked for the future. If that means you have to cancel them, then that is what you have to do. I don't have any control over that. I would suggest, I can't give you any advice, but you might want to contact those property management companies and just let them know that in St. Pete Beach, that's not, you can't have those types of short-term rentals. I'm sure they're very much aware. I'm going to tell you, I'm not trying to be inequitable here. I appreciate you falling on your sword, but buyer beware. When you purchase a property in any jurisdiction, you are required to know the laws of that jurisdiction in order to operate that property. So I appreciate your honesty here today. I appreciate you showing up today. And I will get
a small request.
Sure.
From my understanding here as well, the city does allow transit occupancy of less than 30 days up to 3 times per 12-month period.
Depending upon what zoning district that you're located in, and from what is stated here, you do not, that property is not in a zoning district to where you can do that. It is a strictly 30-day rental period. Is that correct, Ms. Rectischel?
Okay, sounds good.
Okay.
Yeah, no, I
Thank you.
understand.
Yeah, it was worth a shot. I
Yes,
mean,
yes.
yeah.
Now, is there any financial relief you could provide,
I have made my order. If you want to seek the advice of counsel or get with the city to see if there's any options on that, I will tell you that if you come back for any type of a reduction in fines, I've already given concessions for the reduction in fines. If you want a lien request, that's a ball of a different wax. You got to go through the city to figure out how to apply for that.
Sure.
All right. Thank you very much for your time. All right. Anything else that we need to discuss today before I adjourn the hearing?
No, ma'am.
All right. I will see you all back here then on March 9th.
Thank you.
Thank you.